Thank you again to everyone who's here in person. I know we have quite a few people who are on the webinar and some more folks who will be viewing a recording afterward. But I'm Sarah Sumati. I'm the program manager for the Washington New Americans program and the Citizenship Day extravaganza. And we also have Ashley Podpleski and Mallory Thompson who are with the program as well. I'm going to be leading a brief introduction to the Citizenship Day model and how we help clients file for naturalization pro se. And then I will turn it over to Greg Rogers and Emily Headings, who will be talking through all of the legal content behind naturalization. So thank you guys for joining us. What we're going to be talking about today is why we do what we do with Citizenship Day, why it works, what to expect on the day. I know this will be the first time volunteering for some of you. And then Greg and Emily will discuss eligibility requirements, the new-ish N400. It's not so new anymore, but I know that we're still getting used to some parts of it. And going through red flags and determining who should not apply at a Citizenship Day event. So Citizenship Day was actually started by Ayla Washington in 2004. It was the first group processing workshop in the country, and that model has since taken off in other cities all around the country. And here in Washington, it's one of the very few free naturalization services that's still available, and we're very proud of that. The purpose of Citizenship Day is really trying to help people naturalize who otherwise would not be able to, typically due to cost barriers. Last Citizenship Day, I think 92% of clients were within 200% of the federal poverty line, which is still pretty low. And we are able to serve them in a Citizenship Day setting in a really efficient and cost-effective manner. A lot cheaper and a lot quicker than helping clients one-on-one in an office setting. So our model, which we'll go through in detail as we move on, is very light touch. We're not there to represent clients. We're there to help people who would be able to file on their own, file pro se. We're able to give them advice, screen them appropriately, make sure that their forms are filled out properly and that they are including all of the proper documentation. But they will actually mail and file the application on their own. Our goal, if someone comes to Citizenship Day, we deem that they're eligible, they're a good candidate to apply pro se. Our goal is to get them a completed packet that has been reviewed by at least 2 attorneys. We make sure that they know what to expect in the process next, when their fingerprints might happen, what their interview might look like, and get them set up so that they can actually file that after Citizenship Day on their own. We do not file G28s at Citizenship Day for any clients because we're not representing them. We're just enabling them to do this on their own. And we don't track, because we don't file G28s, we don't track their progress. It really is their responsibility to see it through, and we're there for them to reach out and ask questions and troubleshoot later, but we're not representing them. I know that can be very different from people who are used to representing naturalization clients in their offices, so I just want to make sure that that is clear. So on Citizenship Day, which this year is April 25th, we do these twice a year. The next one will be September 19th, but spring is April 25th in Mount Vernon, Tacoma, Yakima, and Vancouver. Attorneys will arrive at 9 a.m. to do a quick site orientation. We are at community colleges for all sites except one. Yakima, we will be at a church, and so we'll walk everyone through all of the stations, explain the materials that are available, touch base on what the flow of the day will look like. The doors open to clients at 10 a.m. That's what we've advertised. We've got radio and TV advertisements running in all of the markets where the Citizenship Day sites are. We've distributed about 8,000 flyers and posters over the past few months. So doors open at 10. Clients usually arrive early. At every site last year we had a line of people by like 9 or 9:30 a.m. So when they arrive, we get them started filling out their intake form. which you guys have in front of you if you are here in person, and then if you're on the webinar, it was emailed to you. It's called the intake and screening form. When they arrive, they'll start filling this out, and this is so we get their biographical data and get a very basic determination of their eligibility. So the date they got their green card, information on their marriages, travel, any interactions with the criminal justice system. They'll get started filling that out and have it ready to go for 10 a.m. when we open. So at 10 a.m., all the attorneys will be in place, and you'll get your first round of clients to begin screening. We close at 3. We try to calibrate the number of people who come in based on the staffing that we have. So sometimes, even though we officially close at 3, we don't take any new clients after 1 o'clock or noon, or sometimes as early as 11, depending on how many people are already in line. But do expect to stay until around 5 p.m. That ensures that we're able to finish up with the clients that we have in place after we've made the cutoff. We will provide breakfast and lunch items and coffee to all volunteers, so take breaks when you need to. Because of the nature of the day, we can't all sit down together and have lunch for an hour, but people can rotate and eat in shifts. But we really want to make sure that you are able to take care of yourself because it's a long day. Okay, there are 6 stations that clients will flow through at Citizenship Day. And this has been, tweaked and altered over the years to try to be as efficient as we can be. The first station is where clients will get their intake form, which we talked about. They will start filling that out when it says page 3 of 7 at the bottom. They'll fill that out. Once their intake form is done, they will go to the first available attorney at the attorney screening station. If the attorney deems that this person is a good candidate to go ahead and fill out the N400, then they'll move on to forms preparation. And that's where we have paralegals and law students who have been trained to sit down and actually fill out the 21-page N400 with each client. We'll have interpreters available should those be needed, although we have quite a few bilingual paralegals. Once that N400 is totally completed, the client will have that completed form and take it to an experienced attorney, a different attorney than they saw in the morning, who will do the checkout, and they'll review every page and make sure that everything is filled out correctly, that any supporting documentation that would be needed to apply is there. They'll do another review of the client's green card. Basically, the idea is another quality check amid the craziness of the day to make sure that we're not accidentally moving forward with someone who really should not be applying on their own or applying at all. If the quality review attorney deems that the N400 and all the supporting documentation is good to go, then that person will move on to the copy station, and that's where we'll make a full copy of their application and their documentation. And that's for their own records to keep to study for their interview. We'll package their application in a certified mail envelope. We'll make sure that they know where to attach their photos and their check or their fee waiver. And then at the exit station, we'll give them any resources that they might need, a list of post offices that are nearby, a list of citizenship prep classes in their area, and they're done. In between each of these stations, we ask that clients check in with the flow manager. There's one flow manager, it's a One America staff person at each site, and that's another quality control check to make sure that if someone is indeed moving between the stations, that we know where they are, we don't lose track of them. We can check and see if anything got left out of their application for whatever reason. There will be runners stationed throughout the day who will be able to walk, if you finish with a client, they'll be able to walk that client over to the flow manager, make sure everything checks out, and then they'll walk them over to the paralegal room to start filling out the form, for example. Okay, I just want to review the 2 attorney staff stations in a little bit more detail, since those are the most relevant to you. You got the bird's eye view, and now here's kind of the closer up view. The first attorney that sees each client for the day, again, they don't fill out the N400 with them. They simply screen them to see if they're a good candidate to fill it out. So the first thing that the screener attorney does when he or she sits down with their client for the first part of the day So you'll want to review and sign this consent to limited representation. It's in that intake form. And this basically just ensures that the client understands that we're not representing them, we're giving them limited advice in this situation, but ultimately they're responsible for providing truthful information so that we can give good advice. We don't guarantee the outcome of their N400. You can read it through, it's in English and Spanish, but you'll want to sign that with the client. And then you'll start reviewing the intake form that the client filled out. And this is where your legal expertise will come in great need. You just want to identify anything that seems like could be a red flag and suss out more information about that. On the first page of that whole packet where it says Citizenship Day intake and screening form, this whole front of that first page are questions that you want to go through with your client and mark their answers and feel free to fill in more information or context if you feel it's necessary. But these questions are all designed to get at really serious issues that could trip up someone in the application process. You want to ask questions in multiple ways. Have you ever been arrested? Have you ever spoken to a police officer? Have you ever been in handcuffs? Any kinds of ways that you already know to ask questions to try to make sure that nothing is withheld. If there's any potential issues that could get someone in trouble with eligibility, or if it seems risky for a client to apply without representation, we want to refer those out. We have a attorney referral list that contains any immigration attorney who has volunteered with our program in the last year is on that list. So we'll give that out to people because we don't want to put forward anyone who might be a risk to apply. If you're in doubt, there will be a senior attorney at your site kind of floating around in that room, and you can flag down him or her and say, I'm not sure about this, this could be an issue, but I'm not sure, and they can help you make that call. You also want to review the client's green card and any supporting documentation. If someone indicates that they have a criminal issue, you want to make sure that they have brought the appropriate documentation. On all of our marketing that we've done for Citizenship Day, we've been very clear with people that they need to bring documents to back up any type of criminal issue. So they should know that, and if they don't have it, then we refer them out, and we don't continue with them that day. If you're going through someone's form and it seems like they're not a good candidate to move on today, they have something in the statutory period, they have a trip of a year over within the last 5 years, something that's clearly that's going to cause them problems, you are going to mark it on the intake form. There's a section that says not eligible or not cleared to move forward today because. You'll check that, fill it out why. And then you'll fill out a red slip for the client, which just explains to them why they cannot move on today. And whenever we see someone walking around with this at Citizenship Day, that way we know to direct them to the appropriate resources. You'll give them the attorney referral list, and then they'll proceed to the exit station. I just want to flag a couple of things. We don't red slip people if they're not fully prepared that day with minor things. If they didn't bring their check for Homeland Security, for example, or if they didn't have their passport photos, that's okay. Those are things that they can do later. They don't need to be ready to put their application in the mail that very day, but we want to make sure that they're mostly ready and any important things are there. So if you have screened someone and they seem like everything's in order, they have no eligibility issues, and they have all of their documentation, then you'll flag down the runner and say this client is ready to go to fill out the form. And then they're off your hands and you're on to the next person. After someone fills out the N400, that's when they'll go to quality review, and this is that senior attorney or more experienced volunteer who can review the completed N400 and the I-912 fee waiver if that's there. Just checking to see if there's any issues that could have been missed. Review the green card one more time. The quality review attorney is actually the person who will sign the preparer's statement. And this is on page 19 of the N400, and you'll see if you're here in person that Page 19 has a sticker that's pasted over most of the preparer's statement. We just want to make it clear to USCIS that you did not prepare this and you didn't file like a G28 for this person, but you'll fill out your name, your signature, and firm name, but then the rest of it will be covered up by a sticker that says that this was a pro bono group assistance event, no G28 has been filed, the event was sponsored by Ayla Washington and NWNA. And those of you who are on the phone or online, you'll see this. You'll see a screenshot of this when Greg and Emily talk about this. The quality review attorney will then go over a what to do next folder, which is just a blue folder that has information like the 100 civics questions, the AR11 to change your address, a little timeline of what they should expect in terms of letter of receipt and the biometrics appointment, things like that. Those folders will be at your station in English and Spanish, and you'll just want to give that to your client and make sure that they understand it. If the person is good to go, then they will go on to the copy station, and you'll be on to the next one. Just quick things before I go to remember. It's super important that you make sure that this intake form is filled out. It'll be a color, so you'll be able to distinguish it easily from other things. It's usually bright yellow. This is the only record that we have of someone's participation in the day because we don't keep a copy of their N400. We don't, file the G28 for them. So we file their intake forms away in our records, and that way we know. Let's say someone calls in 6 months and says, I want to go to Citizenship Day, and I went to Mount Vernon, and they sent me home. I can pull up this intake form, and I can say, oh, John, it looks like you needed your certificate of divorce. Do you have that now? And I can give them the appropriate advice. Or I can pull up John's intake form and I say, John, it looks like you have a conviction for murder in 2000. Really not a good idea for you to apply at any time. That is really, really helpful information for us. I don't think we've seen a murder at Citizenship Day, but there is a first time for everything. So do try, I know it's a crazy day, but do try to fill this out in a detailed manner as possible. Another important reminder, all clients do need to pass through the flow manager in between stations so we don't lose track of them. And all clients, no matter whether they're referred out or if they move through the whole process successfully, they get that what to do next folder. They're completed inside N400. Or, if they're not cleared to move forward, they get that red slip that tells them why they're not eligible to file. At your stations, there'll be binders for attorneys that have things like the classes of admission, information you can give to clients on requesting their criminal records from the court. There's a ton of resources that will be available to you. Part of the orientation the morning of will be, you'll have a chance to look through those and see what's there. And if you have a question during the day, surely questions will arise. Your AILA site coordinator will be there to answer those. There are plenty of experienced volunteers who have been to many citizenship days who will be happy to assist. Okay, and with that, I'm going to turn it over to Greg and Emily to talk through the law.
Thanks very much. So for the people in the room here, who is doing this for the very first time? All right, we have a couple of people in the room, and you on the phone, I'll accept raised hands without being able to see it, but thanks very much for doing this. For those of you who have done it before, you know what a great experience it is, what an exhausting experience it is, but it's really a rewarding thing, and we appreciate the fact that you're prepared to do this. I think one of the things that I'm a private attorney, and one of the things that I think about when I do these is I go in a little bit scared because usually when I'm doing it in my office, I've had a client who's prepared information, I get to look at stuff, I get to plan for it, I know what I'm going to talk to them about. Here, someone sits in front of you and it's right there on the spot and you're just dealing with them for that hour or so or less. But fortunately, there's so many really, really good people who are working ahead of you in terms of the paralegals, getting it ready, that they make the job easy. But I want to emphasize one thing that was said before. Those checklists are really, really critical. I mean, in your office, you get to plan everything. You know what to deal with. But you've got to make sure that the people who are giving you cases have completed that checklist and have done it well. If you're getting things that aren't complete, you need to make sure you talk to that person. And One America has been really good about making sure people are doing those things right, because you depend on them to have done everything they can do, so you can do your job and get the case moved on to the next level. So I'm going to, you know what, I'm going to go on to the basic issues here. Right, good, I've got my issues there. If you look at the N400, the pages, we're going to try to walk you through a fair number of the things here, but the basic issues are who qualifies for it. One America does a great job screening people in advance. You're not going to have people generally who don't qualify on the basic issues. 18 years or older, they have to meet residency requirements, so I'm going to talk about those issues. Physical presence, speak, read, and write English. There's going to be kind of a basic pre-test that the organization does to make sure people who are in front of you have that basic capability, or can be expected to show it by the time they're interviewed at the naturalization appointment. Basic knowledge of U.S. history and civics. If you haven't already done it, it's always a great idea to go to the USCIS website and take a look at the 100 questions that they ask, and take a look, see if you can give the 100 answers to do it right. They have to be willing to take the oath of allegiance. We've got some information about that. And they have to be able to show that they are people of good moral character. So these are things to watch for. So let's talk about these basic, the basic residence requirements now. Lawful admission. You're going to have people who have been lawfully admitted. That's an important thing to deal with. And they have to have been admitted as a permanent resident. One of the first kind of questions and decisions that you're going to be working with then is, are you going to be using the 5-year standard, or are you going to be using the 3-year standard? And the rule basically is, if a person's been been a permanent resident in the United States, married to a U.S. citizen for a full 3 years, living in the marital union, that person can qualify to apply under the 3-year standard. Now, why would you want to use the 3-year standard versus the 5, especially for a person who says, well, I qualify for both. I've been a permanent resident for 20 years. I've been married to a U.S. citizen for 15 of those years. The real issue is we're going to be looking at this statutory period, the 5-year or 3-year window of time, and there can be some complications that cause a person to have a more challenging time to become a naturalized citizen if certain events occurred within that 5-year window of time. So if you can shorten it down so that event of concern occurred 4.5 years out instead of 3 years out, you'd want to use the 3-year time period for a person who's applying for citizenship through this process. There's a little bit different documentation requirements, but it's just definitely something to deal with, and you want to be able to help explain to a person why they might want to look at one or both. And if people qualify easily under both, some people might just opt for the 5-year period because it's a little bit easier to deal with. Some other people that you might be dealing with, and for you yourself if you haven't dealt with it, a person might have said, well, I came to the United States on 1 year as an asylee. I applied for my permanent resident card later on, but I just have been a permanent resident since a year before I got approved. I'm confused by that. And there is this thing called the rollback rules that says that an asylee is considered a permanent resident from a year before they actually applied, and a refugee as of the date of admission to the United States. So it's just something to kind of factor into the process that you've got. This slide here is an actual picture of what the form looks like, and if you look down at number 7, that's the point where you're asking, date that you became a permanent resident, and there are those 5 questions under Part 1 that talk about that you meet each of the standards that I talked about, the 5 or the 3-year period. And remember, box 1 if you're using the 5-year period, box 2 if you're using the 3-year period. We also have some questions about marital status issues, so we might talk about that a little bit later. But those are the areas that I want you to look at there. All right, the next slide then is the residence requirements. Now, you see here that the question says, where have you lived for the past 5 years? One set of boxes. One of the things that is done as people go through this program is they get a very long sheet of information to do all their addresses that they've had for the last 5 years. So you will know much more than is listed just on this, and we have a nice addendum document that can be used for it. So it's important to be able to know all this information, but you'll have it all available to you. Next slide is the one on residence requirements. I call this continuity of residence. How do you show that during that period of time you've had this continuous residence? And it does not mean that, as some people are concerned, you mean I have to have lived here, physically lived here the whole time? No. You can have traveled outside the United States. It's absolutely fine to do. But there are periods of time that if you're outside the United States for too long, or for certain periods, the government will start to wonder or question about it. And so basically, from your standpoint, you just don't want to have a break in this continuity of residence, because if you do, then you have to start the period over again. And so an absence of 6 months or less, totally fine, no issues, people should be admitted, no problem. An absence of more than 6 months but less than a year, it's essentially setting up a rebuttable presumption. The government has some concerns, and it may ask those questions, but it's not generally, for most people, going to be a serious issue. If they maintain a home, a bank account, driver's license, things like that that show that they still intended the United States to be their primary residence. But it can be an issue. But a person who has an absence of a year or more, that's considered a break in the continuity of residence. So it can do a couple of things. One, it can just be a break for the purposes of naturalization, but it can also be a very, very serious issue in terms of a person's status as a lawful permanent resident. And so if you see anybody that has a break of anywhere, and I just kind of figured the 8 months or longer, but certainly a year or longer, it's definitely something you have to spend some time talking with a person about, get some sense of what's going on. And I will tell you, the fact that that person said, well, I did this, and after a year and a half of being outside the country, and I came back, and it was a year ago, and they let me in, they didn't ask me any questions, it doesn't mean that they won't ask questions or be concerned about it as a part of this process. So just the fact that they're sitting in front of you doesn't mean you shouldn't be concerned about an absence of a year or more for sure. Continuity of residence is also required. A lot of people ask this, okay, I file the document, am I supposed to stay in the country now? Can I leave between now and the interview? And in the Seattle area, the interviews used to be conducted about 4 months after you did the filing. They've now moved up to at least 6 months or so, or even longer. I had a client who just got interviewed a couple weeks ago, and it was something like 9 months later. So they really delayed this. And some people, they're going to take off, they're going to go on this travel. Well, how long can they be gone? Again, you want to apply that 6 months or less. That's not a problem at all. More than 6 months and less than a year, rebuttable presumption. And I would be more concerned about it during this time period, because some people, getting their citizenship is the last thing they do before they move outside the country. And so you don't want someone to have moved out essentially in advance of getting their citizenship. So, and some people also wonder about what happens if the person did have a break in their continuity of residence. If you've been out and you have a break, you have to come back for 2 years plus 1 day before you qualify to apply for naturalization if you're using the 3-year rule, or you have to be back 4 years plus 1 day if you're using the 5-year period for the continuity of residence issue. Okay, and are we seeing any questions? You're monitoring questions on that? Wow, we usually have questions by this time, so maybe I'm speaking too fast. The residence requirement, now we're going to look at some of the other issues. Under the residence requirement, there are some special rules. You have to have been resident for 3 months in the CIS district where you're applying, or the state where you're applying. You must reside, as I said before, in the United States from the filing of the application to the oath. Absences are allowed so long as they don't break continuity of residence. And you can actually file 90 days before you reach the 5-year window of time, or even the 3-year window of time, but you have to be careful about the marriage issues. The marriage rules have to have been satisfied if you do that. But you can actually file up to 90 days before meeting the residence requirement, which can essentially eliminate that 3-month residence in the CIS district issue, as long as the person's going to be able to prove that. Another part of the residence requirements, I consider them both kind of similar, is the physical presence requirement. Remember, we're looking at a 5-year window or a 3-year window, and so you have to have been physically in the United States for a total of at least 1/2 of the time whatever statutory period you're using. So you've got these breaks of time, but you also add it all up together, and you have to show that you've been physically in the United States. And for some people, it can come down to as much as literally counting the number of days and getting a sense, did that person meet it or not? And there are some people you might talk to at this program or in your own practice where you might say, we shouldn't file for at least another 2 more weeks. We need you to get more physical presence in the United States before we do this filing. And let's see. Sorry, catch myself up to the slide there. You'll note on this slide here, number 3, list all the trips below 24 hours or longer, because if you're in the United States for at least part of a day, the government will consider that to be a day in the United States, so your departure day and your arrival day are counted as time in the United States. But it only asks here for the trips that you've taken in the last 5 years. Now, those of you who have been doing this for a long time know you used to have to do all absences of 24 hours or more. They no longer ask that. And I think we're still gathering that information, aren't we? As part of our process, we're gathering all of the absences. And so it's, even though you're only on the form required to provide the last 5 years, it's absolutely still worthwhile to look at all those absences to see if there's something in that person's history that could perhaps break continuity, even cause a potential problem for their status as a permanent resident. Yeah, there's the trips of 6 months or more. Some of these slides, I'm like, there's a few extra in here that we didn't quite see. So definitely those 6 months or more is something to be looking for. All right, I'll turn that over to Emily now for her to talk about English language issues.
All right, so moving on to the English language requirement. So speaking ability is evaluated at the interview, and generally the idea is that the person is able to speak, read, and write English at about the 4th grade level. Arguably, the issues in the vocabulary they're going to have to agree or to respond to and to speak about at the interview are higher than that level, but you know that's the general standard. At the Citizenship Day, we'll have information about vocabulary they need to study, and so they can be prepared by the time they get to the citizenship interview. There's a couple of exemptions for people who are based on their age and their length of residency, and we call these the 50-20, 55-15 rules. If someone's at least 50 years old and has been an LPR for at least 20 years, then they don't have to meet the reading, speaking, and writing requirement. Similarly, if they're at least 55 years old and have been a permanent resident for at least 15 years, they don't have to meet that requirement. They do have to take the history and civics tests, but they can do that with the aid of an interpreter. And just remember that the rules apply as of the date of filing, not as of the date of the interview. So they need to meet these requirements when they send in the application, not 6 or 8 months later. There's also something called the disability waiver, and that's for people who have medical conditions that prevent them from being able to learn or remember information. And we're not going to do those at Citizenship Day, but it's good to be able to flag that and provide that as an option for somebody if you believe or if what they've told you makes you think maybe they qualify for a disability waiver. And we'll talk about that in just a second. So then the requirement of knowing a little bit about U.S. history and civics, as Greg talked about, there's the list of 100 questions that you may be well familiar with. At the interview, they need to answer 10 questions and get 6 of them correct. If they aren't able to do that, they'll be rescheduled in about 60 days to come back and have a second chance at that. As I mentioned before, if they are exempt from the English requirement, they still need to take the history and civics test, but they can do it with the aid of an interpreter. One little twist on the history and civics test is if a person is older than 65 years or older and has been a permanent resident for at least 20 years as of the date of filing. They're also exempt from the English, but they also are tested on a smaller number of questions. I think it is 25 that are marked on the 100 questions list. And again, there's the disability waiver that someone might apply for the history information. I'll just talk really briefly about disability waivers, even though we're not dealing with those on Citizenship Day. This is a waiver that exempts someone from the English and or history requirements. It has to be a medically determinable disability, so something that a doctor or a clinical psychologist or a doctor of osteopathy diagnoses and explains why it prevents them from learning. The standard is pretty high. It's unable to learn English and history. It's difficult for them, or they might try really hard and they may or may not be able to do it. It's unable to learn. So it's a pretty definitive determination by a doctor. Examples of some disabilities or medical conditions that might qualify are things like stroke, dementia, developmental delays. We often see refugees with PTSD or depression that might qualify for a disability waiver, which is also called the N648 form. So just information you can provide someone who might mention to you that they can't speak English, or they've tried and they haven't been able to. You can refer them to their doctor to make that determination. All right, so then on the N400 on page 2, there's now a place where you can mark that you're planning to apply for the disability waiver, or that you're eligible for one of the English exemptions that I mentioned. So that's at the bottom of page 2, and you can, applicants can mark their eligibility for those. And there they are. Okay. And then the final requirement is being willing to take an oath of allegiance or an oath of loyalty to the United States. The last 6 questions on the form relate to that, and I find it's often helpful to read over the oath with the applicant before even asking these questions so that they know what they're agreeing to. There is a part of the oath that talks about being willing to bear arms or to fight for the United States, and so sometimes you run into people who, because of their religious or philosophical beliefs, aren't willing to do that. And it is possible to request what's called a modified oath. Basically, that just entails bringing in a letter from your religious leader, or just a declaration about your statement of belief, and then the officers often read that and say, okay, you don't have to take that part of the oath, but that would mean marking no to questions 50 and sometimes 51 about bearing arms on behalf of the United States. So, over to Greg.
We do this back and forth just to make sure people stay awake. Those of you listening at home, make sure you're paying attention to. Well, the good moral character issue is one that is, I think, a real challenging one, just because there's so much subjectivity, I think, kind of in this whole process to it. And so we're going to split this up back and forth as we talk through it. But generally, what you need to be able to do is to show that during the statutory period, the person's a person of good moral character. Again, 5-year or 3-year window. This is when it can become really critical in determining which one you're going to be able to use. There are also permanent bars that just say if you have this issue, you're not going to be able to apply for naturalization, or certainly you can apply, but you won't be sworn in. So we start off with these bars to being able to show good moral character. There are mandatory bars, like the permanent ones I'm going to talk about in a minute. And then there are temporary ones. And these ones are only bars if they've occurred within that statutory window. So if you've talked to a person who's had this issue, but it's 10 years ago, it's not nearly the significant issue it is if it happened over the 3 or 5-year window you're dealing with. There are also these things called discretionary bars, which are bars only if they occur during the statutory period. So we're going to go to the next slide. How do you approach this issue of good moral character screening? And basically a 3-step approach. First of all, is there a bar? That's the first one. Is this person subject to a mandatory bar? And the second one is, could this person be denied based on lack of moral character? And if these are discretionary issues, how will you attack them? Will you be able to show that this is something that isn't worthy of being barred from becoming a citizen? And as you see here on the bottom bullet, the second to bottom bullet, USCIS was required to evaluate the claims on a case-by-case basis, taking into account the standards of the citizens of the community. A few years ago, there was a case involving shellfish, I think it was, and a person got a few too many shellfish in a thing, and they said, well, that's, we're in the Puget Sound area, and can't let, that's bad moral character there. So there can be issues. I think that case was overturned.
Right.
Yes.
That person was found to have good moral character.
That person had good moral character ultimately. It was very good. And really, then the bottom line one, aside from you can tell a person, hey, you can't apply for citizenship or you shouldn't because you won't be able to be naturalized. But the bottom bullet is the worst one, which is if we file, are we essentially providing the government with something that this person is going to be subject to removal? This is the more modern term for deportation. And that's something you really want to be careful that you do not want to be the person who participated in the filing that resulted in a person being removed. So let's talk about permanent bars. These first of all, are mandatory bars, I guess, because in the mandatory bars there are permanent bars. Again, it was mentioned, murder is one of them. If you did a murder any time, you're not going to be qualified for good moral character. And then the second bullet is conviction for aggravated felony. And it's aggravated felony before a particular date. That's when it took effect in the law. And it's aggravated felony not in the terms of what anybody thinks of as aggravated felony in the non-immigration context. It's a very specific but still fairly vague concept of what the term means. So this is one of those cases, again, where our special attorney, the attorney who's familiar with all sorts of other criminal-related issues, will be able to advise you. I certainly know I'm not a person who feels very comfortable making those decisions, and you want to be able to get the person, if you see something that's worthwhile dealing with, get that special attorney to pay attention.
Just a quick comment on that last point that Greg was making. So sometimes you'll see people with a theft conviction, like a third-degree theft and a 365-day sentence, and you'll think, oh, yay, that's not a crime involving moral turpitude anymore, but it's still an aggravated felony with that sentence. And so even though it seems like a minor crime, maybe it happened 15 years ago, that still could be something that permanently bars someone from being eligible for citizenship unless they would get some form of post-conviction relief and reduce that sentence. So it does come up, with some frequency. All right, well, let's look a little more closely at some of the bars in the statute in INA 101F, where it lists certain things that mean the person lacks good moral character. And as Greg pointed out, these are temporary bars, so once these actions or conduct have moved out of the statutory period, then they're no longer an absolute bar. So the first one, habitual drunkard. There was some conversation on the ALA listserv recently about this term, and people pointing out that it's really vague. There's no really good definition for what that means. There's this one old BIA case that's cited here that talks about it being something like a chronic alcoholic, but there really isn't a great definition of what that means now and who makes that decision. Although arguably we would say, okay, it's not an immigration officer who can make that determination. That's more of a medical decision. But again, things like alcohol-related offenses might raise this flag if there's a number of them within the statutory period. Generally, one DUI within the statutory period isn't going to raise this issue, although it could raise other good moral character issues that fall more into the discretionary decision. The second one, illegal gambling. This is if someone's had convictions for illegal gambling. I've never seen that bar in my practice, but I guess that could certainly happen. The third one, again, about gambling offenses. Again, you have to have convictions to fall under this bar. The fourth one, it might be something you would see more frequently, giving false testimony for purposes of getting an immigration benefit. I mean, it's a fairly specific bar. The testimony has to be oral, not something written on an N-400 or an I-485. It has to be something that was given under oath, and there's not a requirement that the information have been material. Although if it was made for purposes of getting an immigration benefit, then it might be harder for the government to show that it was made for that purpose if it isn't material to eligibility for whatever that benefit is. And there's a good Supreme Court case that talks some about materiality and what that means, especially in the NATS context. And this sometimes might come up too. If someone applied for citizenship, say 2 years ago, they were denied because of false testimony or for lack of good moral character, you want to make sure that well, it's out of the 5 years, or that it doesn't fall into that ground. And I think sometimes immigration doesn't apply this one correctly, so you want to look at it carefully and see that it meets all these different things that are required for it to be to fall into this bar under 101F. And I guess there's some case law too about misrepresentations that are made for reasons other than obtaining a benefit, such as if someone's embarrassed, they don't speak English very well, they you wanted to keep something private. Those aren't reasons for the incorrect information to fall into this bar. So it seems like there's a number of ways to get around this, and this is very specific. All right, any questions about that? Right.
Thank you. All right, the next set of mandatory bars and a temporary bar basis, only if they occur in the statutory period. Confinement to a penal institution following the conviction for an aggregate of more than 180 days. It's more than 180 days? I see 180 plus days. There's 180?
180 or more.
Okay.
Yeah.
The next one is conviction or admission of a crime involving moral turpitude. And so this admission issue is a really important one to think about because there are all sorts of places where an admission could occur. One of the reasons why I'm always worried about police reports is what they say someone said in a police report, things like that, or admission to an officer. But it's important to note that there is what's called a petty offense exception. So if it's only one crime involving moral turpitude, maximum possible sentence is a year, sentence is 180 days or less. Stuff there. I need to point out an error in the slides here, slide 30, where we talk about what slides to look for better definitions of conviction, etc. It should say see slide 32 for conviction, slide 34 for admission, and slides 35 through 36 for a CIMT. So please pay attention to those. Next one is one of the temporary bars, conviction or admission of a controlled substance offense. And remember, folks, the fact that Washington has its own rules for marijuana, there's different issues for people who are permanent residents to watch for. Number 8.
Just to add,
yeah,
so
yeah.
There is that exception for 30 grams or less of marijuana, which that might fall into
Definitely, I would think
the
so.
the Washington law.
And we're going to talk about the 30 grams or less exception in just a bit. But it's very confusing, I think, to our permanent resident or visiting people on H or L or any other status. There's this law in Washington that says you can do it, but the federal government says that's a state law. That is not a federal law, and we're enforcing the federal law, so watch out for that. Number 8, the conviction of 2 or more offenses with an aggregate sentence that was actually imposed of 5 years or more. That's the reference there. And these are all temporary bars to showing good moral character if they occur within the statutory period.
All right, so continuing on with the mandatory bars that are found in 101F, if an immigration officer has reason to believe that someone's a drug trafficker, again, this is referring back to the inadmissibility ground, as many of these bars are. And again, this doesn't require a conviction of a controlled substance offense, but just facts that or alleged facts that the officer might look at to make a determination that the person's a drug trafficker. Number 10, if the prostitution, there's a couple things about this. So it refers back again to the inadmissibility ground, which has to do with engaging in prostitution. This implies that it's not just one act, but it's repeated acts or a pattern of behavior. And it's within 10 years of admission or adjustment. So there's sort of that time limit also. Now, so the prostitution good moral character bar shouldn't be confused with whether prostitution or solicitation of prostitution may also be a crime involving moral turpitude if there's a conviction for that. So just because the person didn't engage in prostitution, they still may be barred from showing good moral character if they would have a conviction of prostitution or solicitation. And there's some recent Ninth Circuit case law on that. I think we might have that citation later on under deportation or CIMT. But for purposes of the good moral character bar, it's needing a practice of this type of conduct. All right, so 11 is alien smuggling. Again, this doesn't need a conviction. If the officer believes that someone was an alien smuggler, and when you look in the statute, it's very broadly written. If you've aided, abetted, encouraged, somehow helped someone to come to the United States, whether that's sending them money, providing them a ride, then you could fall into this ground if you did it within the last 5 years. Sometimes that requires getting Border Patrol records, doing a FOIA for that. Again, we wouldn't be doing that at Citizenship Day. If this issue seems to be there, we would refer the person to a private attorney. Again, a conviction for alien smuggling would likely fall into the aggravated felony ground, and so that becomes a bigger issue then if there's some criminal charges involved. Number 12, if you're coming to the U.S. to practice polygamy, that's a bar, and if you did that within the last 5 years, this isn't just someone who's been married to 2 people at the same time, either by accident or because they didn't know they weren't divorced. It's having that belief system and having multiple spouses. So is this me still? Yes,
yeah.
Okay, so let's look a little more carefully. Probably many of you are aware, under immigration law, conviction has a very specific definition, which comes from 101A, 48A. So it requires 2 things. A judge or a jury has found the person guilty, or they've pled guilty, or they've admitted sufficient facts to warrant a finding of guilt. So in addition to that piece, they also have to have some sort of penalty or punishment that was put on them by the judge. In Washington, that means you're looking more carefully at cases that were resolved by deferred prosecution or pretrial diversion, or might have a stipulated order of continuance, and to see if those types of resolutions fit within this definition. Because sometimes you might get a dismissal, but it was based on deferred adjudication or some other type of pretrial process, and it could still be a conviction, and the person thinks, oh, that was all taken care of, it was dismissed, but actually it was a conviction under immigration law. So if you have someone that seems to be the case, we have criminal attorneys at Citizenship Day who can review those documents and determine if something was a conviction. And as we noticed in the good moral character bars, a lot of them rely on having a conviction, and in some cases just the conduct. All right, and it's often important to, if someone indicates they've had an arrest history or been in court, to search out their criminal record if they haven't already done so. There's some online resources there that are helpful. The first one is free, and so that's nice to use. And then there's the Watch, which is the State Patrol, but now I believe that, that you have to pay to get those results. Neither of those are completely comprehensive. Sometimes if a person's lived in multiple places and they can't remember the details of their history, it's really helpful to get an FBI record. That adds months to the process, but it's important to get that. If you think it applies, that's at least the one thing that USCIS will have. All right. Now, so some of the good moral character grounds relied on just a person admitting sufficient facts for a crime involving moral turpitude, for example. But there are specific requirements for what constitutes an admission. And there's some BIA case law that talks about what's required. So it's not just saying, yeah, I did that to the police officer. It's admitting the specific elements of the crime, which might even include an intent element. It's being given as a definition of what the crime is. It's doing it voluntarily, not under duress of any kind, and admitting all the facts that constitute that crime. So although you want to, people need to be aware that they shouldn't just be admitting things willy-nilly. There are specific things that are required to make it an admission. And Greg, I will turn it back to you to talk about CIMTs.
Which slide are we at now? 35. Just a second here. I'm going to do a quick catch-up. Okay, well, what is not a crime involving moral turpitude? Because just because you see this doesn't, some sort of criminal event doesn't mean that the person's not going to be able to qualify, or that even the time involved in that period is an issue. So simple DUI, as you talked about before, is one that's not simple assault. Even if it's a domestic violence matter, and the fact that there's a domestic relationship alone is not enough to make it a moral turpitude issue. Assault 3 under RCW with mens rea of negligence, so no intent there. Criminal trespass, traffic offenses. A lot of people ask, well, I've got traffic tickets, things like that. Are those going to stop me from being able to apply for citizenship? Some may. If a person had, like, was speeding a couple, over 100 miles an hour maybe or something like that, but simply driving without a license or without insurance are not enough to cause a person to be considered having a crime involving moral turpitude. And then in Washington, certain theft offenses are not crimes involving moral turpitude, and you see there the notation below that to be a CIMT, theft must include the intent to permanently deprive, and that's an important thing. Now, I'm not so familiar with the categorical approach, and maybe you might want to mention something like that as we come into we've got the next section, but I don't have anything on categorical approach issues.
Okay, and I mean that's just the way that a judge is to look at a statute to determine if it falls within one of the categories in immigration law that's problematic. And so we've had recent good Supreme Court case law about sort of reclaiming that and saying this is what you have to do. You can't just immediately go to the record of conviction.
Perfect. Great.
So,
all right, I'll move it over to you.
So what are so the statute doesn't specifically say these are crimes involving moral turpitude, right? They give some general guidance about that, but generally it's defined through case law, which crimes are and which crimes aren't. And generally crimes of theft are considered crimes involving moral turpitude, but given the recent Ninth Circuit and Supreme Court case law, the theft statutes, all of them, first, second, third degree theft, are not considered CIMTs any longer, which means if someone has a theft offense within the 5 years, arguably that's not a bar to showing good moral character. You might have to provide some positive, good moral character evidence to kind of balance that out, because any negative or criminal conduct can be considered in kind of the weighing of the balancing of the good and the bad in making the decision about good moral character, but it's not an absolute bar at this point. Now, you should remember, though, if it's a theft with a 365-day sentence, it's still an aggravated felony, which is a permanent bar. So even though it's not barred as a CIMT, it could be barred as an aggravated felony. Other types of crimes that have been found to be CIMTs, where there's an element of intent to defraud, if there's an assault with a mens rea of more than negligence and some sort of aggravating factor. Solicitation of prostitution has recently been found to be a CIMT, and also prostitution itself under recent Ninth Circuit case law. DUIs generally aren't unless there's specific mens rea. If there's a knowledge that their license was suspended, there's one case in Arizona that found that was a CIMT when he was convicted of DUI under a statute that had a specific intent requirement.
All right, so now we're moving on to the discretionary bars. Now, remember, these are still bars. These are not the mandatory bars that apply, but USCIS will use its discretion to bar a person if the act occurs within the statutory period. It's the act when it occurs, unless you can show extenuating circumstances. And there's the reference there. Unless you establish extenuating circumstances, it will be found, the person will be found to lack good moral character if the person, for instance, and here's a series of things, willfully failed to support dependents. It's one of the reasons why there's questions about how many children do you have, where are the children, all the children, marriages, things like that. Extramarital affair that destroyed an existing marriage. It's an interesting one. Haven't had any cases that I know of that where someone was found to have had that event occur. Committed an unlawful act that adversely reflects on good moral character. That is pretty broad. So you're going to really want to kind of think about what the issue that occurred there was, and whether it might potentially be good moral character, and be prepared to have a person defend against that. failure to file or pay income taxes. Now, that's a situation that is encountered fairly often where people haven't paid their taxes. But if a person has contacted the IRS, if they are on a payment plan, that person, and they have the documentation to establish that, that can be enough to get past this issue of the discretionary bar. You don't have to have paid it all off by the time that you go to the interview. Number 5, the failure to register for selective service. We're going to be talking about selective service in just a moment. This obviously applies only to males between the ages of 26 and 31, including ages 26 to 31. Failure to claim, a false claim to citizenship, and that is another issue that's one of those things where a person may be subject to removal as well. So you have to be especially careful about that. We'll be talking about that issue a little bit. Also, illegal voting, subject to other slides that we have in the program. And again, subject to potential deportation. So big issues that occur there. You can see here at the bottom here, the regulations say that they can't naturalize someone who's on while the person's on probation or parole. We've got some district court cases there. So selective service. All right. So it's an issue that surprises people quite often. You'll have a person who says, "Well, wait a second. I'm not a citizen yet. How can I had to register for the selective service?" But it is a requirement. All males 18 through 25 have to register, except non-immigrants. That means even if a person is here in an unlawful status of some sort, undocumented, you may have that obligation to do it. And so it's easy to do. Most offices have it. And one of the things that One America does with these programs is it's a really easy way to find out. We have the capability of determining on the spot whether a person did or did not register. Some people will be able to register there if they wish to. You can pretty much, I know, my way of determining it is when you ask the question, if someone looks at you kind of shocked and surprised, like, well, why would I do that? That doesn't make any sense. It suggests to me that it was probably not willful and without intent. So, but it can be a good moral character issue. But as soon as you register, that can be good. If you're outside the statutory period, if you're past the age where you could be brought in through selective service, and you'll sign a document, that's usually enough to get you past that. I've never had anybody had any issues with that. It's in the period where we don't have a draft. We have places where you can check, and like I say, even if you're not outside the period, you can still show that you are a person of good moral character. You can show it's not willful, and you submit a statement. We have those statements. We have them drafted there, right there, for a person to be able to sign and send in right on the spot. Obviously, you don't want to have a person sign it if you don't believe that they did it willfully, but it's definitely something to deal with. And we can get a status information letter from the Selective Service Administration that actually shows a person's status during the ages of 26 through 30.
All right, so we're going to look at unlawful voting and making false claims to U.S. citizenship, only as they apply to good moral character at the moment. But there's also going to be a slide about them as grounds for removal. So for purposes of good moral character, it's not an automatic bar, even if you did it within the statutory period, either of those. The Child Citizenship Act has an exception for people who voted or made false claims to citizenship if their parents were U.S. citizens, if the person was a permanent resident before age 16, and they just believed that they were a citizen and they should vote, then they're kind of exempt from that being found to show a lack of good moral character. There's other reasons that someone can show that it wasn't a lack of good moral character. And that last point that refers to I guess it's a INS memo. Is it a CIS memo? Anyway, it's a memo that talks about how officers should handle people who voted unlawfully or who falsely claimed to be U.S. citizens. And it essentially allows for a lot of discretion in hearing how that person did that, if what kind of mistakes or happened, and generally allows for a good faith mistake and not to be held against someone. If the person has been convicted of unlawful voting, that could also be a crime involving moral turpitude, which would possibly be a bar to showing good moral character. But I think the general rule is it's not an automatic bar. just get the facts and information about what happened when that person either registered to vote and made a false claim or when they actually voted. All right, and then there's specific questions on the N400 that ask about this, claiming to be a U.S. citizen, having registered to vote or voted.
I think we're kind of coming into the home stretch here on some of these things. Other reporting. All right, well, this page is one of the pages with the newer information that didn't used to be on the old N400. And I think perhaps the purpose of this page is to show that there are some very complicated words that are being asked of a lot of people, that the lawyers look at them and say, this is very complicated, and you're asking people, lay people, to try to figure these out. Were you ever involved in any way with any of the following? And then it goes through all sorts of interesting issues. And it's just a difficult process to go through. You really want to ask questions of people, especially perhaps if a person has come through refugee status or something like that. I know I've encountered cases where a person got refugee status, and then later on the Immigration Service has come back and said, yeah, we kind of realized we think you were in a paramilitary unit, or you were providing service to the other side, things like that. So there are definitely issues to be watching for as you go through this one, to try to sort through, make sure the person understands them and answers them. And I believe one of the things that's important here as well is just going through and checking everything. There are ones that you don't have to check, so be careful not to just go through and check too many things, or some that you only answer a question if the one in front of it is answered yes or no. I've got a question here in the audience.
Yeah, so the person was just in the military, which is pretty common. And then you would check yes for military units.
So the question was, if the person was just in the military, which is a very common thing in many countries, it's a mandatory thing for many people, would that person check yes? And yes, they would. They would check yes. And in fact, it'd be really important for them to check yes if they came from a country where military service is mandatory, because it would look really odd otherwise. And it's just a basis for the Immigration Service to have a potential to inquire further about other issues. But yeah, I would definitely check yes on the first one.
Would you fill out an addendum explaining?
The question is, would we fill out an addendum? I don't think there would be a reason to do an addendum, but I think what you might want to do when you see that check yes, because it's going to be that kind of blip outside the columns that you're looking at, is to ask that person, what was it, why was it, when was it mandatory or not? So you can get a sense from them whether this is going to be a potential issue, it's going to be either a problem or no, that's not an issue at all.
Well, I mean, and there's different ways of doing it. I would probably write something down, especially since the person's going in pro se.
Yep.
Then, which it wouldn't necessarily be problematic, but because I wouldn't be there to help, I would probably encourage them to, or help them write down or why they answered yes. I mean, especially, if someone served in the military, they're potentially answering yes to, were you ever part of any group that used weapons against someone? Did you ever provide weapons to someone? Did you ever receive military? I mean, it's a lot you could potentially answer yes to, and I think I would feel more comfortable helping them frame that, how they're going to explain that.
So maybe the possibility of you've got your pad of paper there in front of you, and maybe putting a thing like saying page, and I don't know what page it is, number 14. I want to use 14. It's not what we want to use. 15A. And so you do that, and maybe just say, let's talk about the words that you would use, and maybe work with them to write down a few words, and then say, this is something you might want to consider taking with you when you go. Or would you think of actually sending it as a part of the file?
I would send it as an addendum. Don't we have addendum sheets that we provide?
We have a blank general one that they can fill out.
And so the comment is we have a blank general addendum sheet, so that's definitely so great to do to be able to put that, something like that in follow-up.
Sorry to draw this out, but and the procedural questions, is it the screening attorney or the review attorney who's doing those kinds of addendums? Because they're pretty common.
So the question is, who would be doing this addendum? Would it be something that would be occurring right at this final desk that you're sitting at the attorney desk, or would it be part of the paralegal screening?
It should be the screener attorney or the quality review attorney. At any point, that's fine. If they come to the quality review attorney, they'll review them. If the quality review attorney sees a need to fill out an addendum that doesn't exist, then
no need to apologize. Good question. Thank you. It's a good conversation. Right? Yep.
Okay, so I think we just have these pages to demonstrate how many questions there are related to good moral character and that sort of refer back to inadmissibility grounds. With the new N400, they kind of incorporated some of these statutes that hadn't been incorporated into the N400 before that had to do with child recruitment as soldiers and some of the more obscure inadmissibility grounds. So just sort of highlighting that. There is a pretty hefty part about criminal activity and arrests and stops, and so they'll come to you with their sheet filled out about arrests, but I think it's helpful to ask these again in separate ways, like in different ways, like Sarah had mentioned. What else to say about this? Other than if the person does answer yes to this, they'll be referred to the criminal attorney, the special attorney on this site here. And again, I think this is just highlighting the sort of the complex, multifaceted nature of these questions and how it's helpful to break them down as far as did you commit a crime, did you assist to commit a crime, did you attempt. Hopefully some of that information would be on any court records that the person would bring. And then pointing out that if they're still on probation or parole and it seems like they will not be off of that probation or parole by the time their interview comes around, we would advise them to wait on filing. All right, so what do we include when we're listing someone's arrests or convictions? There's no time bar, so it's listing any arrest or criminal matter you've had ever in any country. I recently had someone from Vietnam who had been arrested for selling dollars when she was in Vietnam before she came over as a refugee. So that was something we had to put down, and we weren't able to get records, but we needed to explain that. So we say because it says citations, we include traffic tickets, even things that aren't criminal matters. The applicant should know immigration's going to have your background information. It's best to disclose this all so we can provide the best advice possible. Of course, they should have all their court records before they apply for the attorney to review. We don't recommend submitting arrest records, but occasionally USCIS will ask for that, especially for arrests during the statutory period. And again, we talked about probation. Being on probation during the statutory period isn't a bar, but if they're still on probation at the time of the interview, it could be a problem. All right, to practice selective service.
There we go. So it sounds like we're bouncing back and forth on some of these things, but there are additional questions. We want to let you know about selective service. Here you can get a sense of what those questions are, and you see date you registered, etc. Again, we can find that information out, but also the one that's just been circled. That status information letter, the person's 26 years or older and did not register, you really need to get that status information letter. I think we've had some people who have actually brought without the letter but brought it to the interview. That's been fine. There's generally not an issue there. But certainly if you can get access to it beforehand and include it in the body, that's a really good idea. Let's talk about practice tips on good moral character issues then. So remember, it's the date of the bad act. It's not the date of the conviction. It's not the date of these other things. It's the date the event occurred that you're looking at for looking at that window of time and whether it's something that's going to be a bar or not. Again, if you look at something, you see it happened 4 years out, and you've got a person who qualifies for 5 or 3 year issue or for the 3-year statutory period, so that you're able to push that outside for the bar problem. For some people, you'll be talking with them, and it's like, you know, you really can't apply now, or you shouldn't apply now. Wait for a little while, and after this particular date, then you should be able to apply because you pushed that event outside the window of time that's an issue. And for criminal records, whether it's for this program or not, you want to see it. It's really important these have to be certified records. They can't just be something that a person just brought in some copies that they made off a copy machine, etc. As Emily said, sealed police reports, I think, are just horrible things because you never know what goes into a police report, and it could be completely different than what on report records. So just you don't send in sealed reports. I've even had them for some of the NATS exams I've had. They said, bring in these police reports. We brought them in, but it was just there's no way we were going to show them to them, and they were able to get through and make the decision without it. So, but it's sealed police reports are a problem.
All right, so then we're going to look just really briefly at some removal issues that might come up in talking with a person. Again, this is the sort of the third step in doing the good moral character analysis, screening for removability. Sometimes we might screen someone and say, hey, it looks like they could be removable because of a certain conviction or conduct, but they're eligible for a particular form of relief. If it's a really strong case for relief, we might go forward anyway, but that probably won't be the case here at Citizenship Day. But just keep that in mind. Someone who's in removal proceedings cannot NATS. We occasionally get a surprise when we find that someone was in removal proceedings, they applied to NATS, and then they're denied because you can't NATS while you're in removal. So then you need to go back and terminate the removal proceedings, presuming there's a basis for doing that. It's also possible sometimes to terminate based on having a pending NATS application and being eligible to NATS. But it has a couple of different requirements for that. And it's not a sure thing for sure. All right, so just sort of looking at basic removal grounds, this is just a list of different types of aggravated felonies that you might see. Common one is a crime of violence. That's very specifically defined in the U.S. Code. Importantly, Washington fourth-degree assault, which is one that might be more common, is not categorically a crime of violence. But I've seen recently that trial attorneys are still saying if you have a fourth-degree assault and a 365-day sentence, they might just raise the question of it might be an aggravated felony. So you might, recommend that someone gets post-conviction relief if you see that, if someone is with that. Theft offense with a 1-year sentence, that's an aggravated felony. Firearms trafficking offenses, crimes of fraud or deceit with a certain amount of loss to the victim. And there's many others, as many of you know. Let's look at the removal grounds for false claim to U.S. citizenship and unlawful voting. Now, for a false claim to U.S. citizenship, which is made for the purpose of voting, it doesn't require conviction. You need just a couple of things. You need the act of unlawful voting, or the act of voting, and having violated a specific election law. So just the fact that they voted doesn't mean that they fall into this removal ground. You have to look at the law in effect in that jurisdiction, whether it was a state election or a federal election, and see if they actually violated the law. Similarly, and also I wanted to point out there was a recent, I think it was today actually, Mike McGinn had an opinion piece in The Stranger about arguing for non-citizen voting in Seattle. So, some jurisdictions, I think there's very few of them, might allow non-citizens to vote. One example he gave was Tacoma Park, Maryland. So, that would be in their local election, of course. So, similarly, false claim to U.S. citizenship for purposes of voting, you need some specific things. They need to have represented themselves as a U.S. citizen on or after this date in September 1996, and they had to do it for purposes of voting. So, you want to see that those specific things were met before just conceding that they were removable for that, under that ground. There's exceptions that I mentioned before for kids whose parents were U.S. citizens and they were permanent residents and reasonably believed that they were able to vote or that they were U.S. citizens. And then there's just a site there from the Ninth Circuit about looking at the specific election law in effect and to see if the person actually violated the law. In that case, it was they didn't have a particular intent, so they didn't violate the law.
So there are certain additional removal grounds that we want to talk about. That again, these are the issues. Yes, we've got a question.
I have a question about I-9 and false claims to citizenship. I know that
So the question is, I-9, the Form I-9, which the newest version of it has 4 questions, one of which is, are you a U.S. citizen? And if a person may have answered that, is the Immigration Service using that as a part of the basis? And are we doing any screening that involves it? I don't believe we're doing any screening directly as a result of that. And I'm just going to kind of, so I don't have a solid answer for you, but the newness of the form with the 4 questions, it's only about 3 years old now.
I think it's
2000, oh, it's more than that. Boy.
Yeah.
When I
So
get older,
we
time
might
gets,
start seeing
yeah,
this.
we might start seeing that people who are coming in and after the 5 hours. So it's definitely something to be aware of. It's something to look at. So far, I'm not aware of any particular cases that have been used where they've said that is because part of it is you're not getting a direct benefit from the government as a result of that.
Yeah, well, the BIA case said it was a benefit from the government.
So she's aware of the BIA case. This is it was, and then the government get it off the border. So, yeah, I don't have an answer for that.
Okay. I mean, I would tend to just ask people, have you ever marked on a form that you are a U.S. citizen, and see what they say. I don't know as much about if they're coming forth with I-9s and that's because I have problems with that.
But I think that was, we also all saw that question. We said, yeah, that's exactly why they're doing it. So it's something to watch for. These removal of other grounds issues, crime involving moral turpitude within the 5 years, or 10 years in the case of a person who is provided permanent resident status under 245I, and is convicted of a crime for which a sentence of 1 year or longer may be imposed on persons deportable. Certain firearms offenses, then 2 or more crimes involving moral turpitude that are not arising from a single scheme of criminal conduct, and it's regardless of whether confined, and regardless of whether there was a single trial or not, that person's deportable. The controlled substance thing, Emily and I both talked about it before. There is the exception that single offense involving possession of for one's own use of 30 grams or less. That's the exception, but otherwise the person is deportable. Crimes involving domestic violence, stalking, violation of protective orders, certain crimes against children, those things can be result of cause for removal. Additional ones on this one. Talked about the conviction of a crime involving domestic violence, protected person, crime of violence, inadmissible at the last admission. That's an interesting one. Drug abuser or addict, and alien smuggling, even if a relative, but there is a waiver for permanent residence, including spouse, parent, son, or daughter. So that, a lot of people don't think about it, but you're driving across the border from Canada, and if that person was the driver of the car and they were lying about someone in the vehicle, that could be considered alien smuggling. So it's just something to pay attention to. Emily?
Okay. And then I think this next part is just to point out where on the form they might be trying to suss out some of these removal issues. There's questions about spouses, current and former ones, that could bring out issues related to marriage fraud and that ground of deportation. Again, under Part 11, a lot of these are good moral character, but also related to deportation grounds. They ask specifically about marriage in order to get an immigration benefit and making misrepresentations for public benefits, which could involve fraud, also misrepresentation can be a good moral character issue. Again, questions about giving false information to the U.S. government and finding out about the person's removal history. I don't know if we're doing this at Citizenship Day, but you can always call the EOIR line to find out what a person's deportation history is if there's some doubt about what might have happened in a hearing, in order to answer those questions accurately.
All right, the next one's up. Okay, there we go. Acquired citizenship. Next one's a fun one. I hope you're at a session where you find out the person is already a citizen who's in front of you. And it does happen at these programs. You always want to ask the person whether they have U.S. citizen parents or grandparents. The nice thing is that N400 has a series of questions that can really help with that. It just calls it to the attention of people. And we've got those citizenship charts to be able to track the records there to determine whether a person is a citizen. I've been at one of the sessions where it happened. Oops, I just went through that one. So there's here's the information about the acquired citizenship stuff. The person might really wonder why. Like I said, I hope you're there to tell them because you're a citizen, you don't get to do this application. The Child Citizenship Act, again, something that's really helpful, saves people a lot of money, time, and effort. Children are automatically citizens when these conditions are met. The child's under the age of 18, one of the parents naturalizes, the child is residing in physical and legal custody of that parent as a permanent resident. That child doesn't have to go through this process. You won't be seeing them, but if you see their kids there, I mean, and you're going through the information, you may be able to say your child's going to become a citizen as a result of what you're doing. And this information about children is on the form. I want to point out this information on slide 51. Again, a lot of people just kind of wonder about it. Sometimes they think, well, I only have to provide information about the children who are living with me in the United States. And just look at some of these things. It's children who are alive, missing, deceased, born in the U.S. or other countries, under the age of 18, older than the age of 18, currently married, unmarried. It's basically saying any child. The government really wants to know that. And obviously one of the problems could be if a person didn't provide this information, and then later on the child applies for some sort of benefits. They weren't shown here. Someone lying or not providing all the right information. So it can be a bit of a challenge. And I think that gets us, are you going to be doing this one, or do we do this? Because every year everybody said, how do I sign this form, especially if I don't do a G28?
Yeah, I can go over this really quickly. So this is just a sample version. You all have it in front of you, but we have a little sticker that we paste over the prepared statement. So you'll fill in your name, the date, and your firm, and then sign it. But then the sticker will cover up the address information, and that just certifies that this was at a pro bono assistance event. The G28 was filed. We've been submitting the forms with these stickers for the last year, ever since the new one came out, and have had no problems with USCIS, the barcode, everything seems to people are fine, they're accepting it. We'll have extra stickers available, but all of the forms at your sites will be pre-prepared like this.
All right, so this last part is just if there was an interpreter who was used to help complete the application, they need to sign here. As well as the person who's applying, signing to show that they understood everything the interpreter said. And this is particularly required if you are eligible for the exemption and for the disability waiver. Are we going to talk about fee waivers, Sarah?
Oh,
I can do that if you want, or do you want to? So I guess this year we are helping with people who aren't able to pay the application fee. This is $180. And the paralegals, it looks like, will be screening for that, and then the attorneys will review the completed I-912, which is the fee waiver request. There's various bases on which the person can be eligible for a fee waiver. If someone in their household receives a means-tested benefit, food stamps, TANF, Medicaid, cash, assistance from the state, such as it's called the ADD, also, if the person's household income is below 150% of the poverty level, based on last year's tax return or current pay stubs, they could qualify. We found those are a little bit harder to get approved. Benefits is usually slam dunk for the fee waiver. Household income under 150, it might get kicked back a couple of times, but it's definitely a basis in the law. And then if there's some other compelling financial need, such as a huge medical debt or other expenses that are able to be explained and documented. And it says we don't do these, but don't we do them? I thought we were doing them this year. Sorry.
The financial need.
Yeah, we don't do Part C waivers. They're just really hard to get approved, really extensive to document. We try to do Part A and B only.
Okay. Okay, so basically there'll be charts with showing poverty level on site, and you can compare income to those numbers, see see if they have documentation of public benefits, which is often in the form of a letter from Washington DSHS or perhaps Social Security Administration. You might want to make sure that someone is not incorrectly receiving benefits. I think that's what this refers to. If they receive benefits within 5 years of coming as an immigrant, that could be problematic. For example, food stamps, that's okay, but other cash benefits may not be okay in the first 5 years of permanent resident status.
Thank you everybody so much for being here. We're recording this session and we'll be emailing it out to everybody in case you want to refer back to it. And I believe everyone received the attachments as well, the N400, the screening and intake form, the station instructions, which just go into a little bit more detail than I talked about in the beginning. This is our contact information. You have many emails from us if you need anything between now and Citizenship Day. And then one last note, if you have friends at your firm or in your social group who might be interested in volunteering, all sites except Tacoma could really use more help. If anyone wants to volunteer for Tacoma, we will happily accept them as well. But we still are recruiting. Citizenship Day is about 2.5 weeks away. And we are very, very much looking forward to working with all of you. And so if we could unmute the line for questions. I don't really wish I could do that, but I don't do it. Otherwise, people can type them into the chat box. Have you gotten any questions? No? Okay. If there are any other questions from people on the line, feel free to email those and we'll get them to Emily and Greg, or if there are questions for us about procedure, we can answer those for you. Okay. Thank you.